We have a verdict in the Roman Storm case. Fill us in on everything we need to know about that, and let's camp out there for a little while here at the very top.
Yeah, we did in fact get a verdict in Roman Storm's case about the Tornado Cash privacy tool. This had gone to trial after Judge Fela, who's the judge in the Southern District of New York, had denied the motion to dismiss in this case on the legal issue about whether or not non-custodial tools could constitute money transmission under the Bank Secrecy Act and Section 1960. And this was always going to be a little bit of an uphill battle in front of a jury. In the American legal system, juries decide questions of fact and judges decide questions of law. And so this was an opportunity for the jury to look at each of the three crimes that Roman was charged with and decide if, based on the facts that the government presents as evidence, that beyond a reasonable doubt he was guilty. So there were three charges in this case. There was a conspiracy to commit money laundering, there was a sanctions evasion charge, and then there was a unlicensed money transmission charge. The jury was unable to reach a unanimous verdict as to the money laundering charge or the sanctions evasion charge. And so the government could retry each of those crimes in a future trial, but probably not super likely to do so. And they got a unanimous conviction on the unlicensed money transmission charge. Now, despite the fact that the unlicensed money transmission charge has the word unlicensed in it, the specific conduct that the government is alleging here has nothing to do with having a license. There is a subpart or an object of the conspiracy that Storm was charged with that requires transmitting funds that Storm knew were the proceeds or derived from the proceeds of criminal activities. So this is something you could be charged with even if you actually had a valid license. And so the jury necessarily found that Tornado Cash transmitted funds and that Storm knew that those funds derived from crime. And again, knowledge here is different than intent, which Storm was charged with in the money laundering charge. So it's not that Storm intended to help criminals. It's just that he knew criminals were using the tool. So the part of this that's a real awful from a precedential perspective is the idea that a non-custodial tool like Tornado Cash, as opposed to the users of that tool, transmitted funds to begin with. Based on the 2019 FinCEN guidance, which maybe we should come back to and talk about a little bit, and based on the sort of just plain English meaning of accepting and then transmitting funds, you would think that it is the users of Tornado Cash who use their private keys to deposit ETH and withdraw ETH using a zero-knowledge proof were the ones who were transmitting money privately, and that it was not Storm who did not have access to those funds, did not have the ability to upgrade or change the smart contract or move those funds. He was not the one who was transmitting the funds in question.
So real quick, Zach, how does that happen then, right? Like we know that seems obvious. Is it just, this is what happens when you go to a trial? Like, is it, what do you think? What do you think? What wires got crossed?
So before it went to trial, there was the legal argument on the motion to dismiss as to whether, as a matter of law, the judge in this case should have dismissed that charge by saying, listen, if you look at the Bank Secrecy Act, which treats you as a money transmitter if you accept and then transmit funds, that somewhere between accepting and then transmitting funds, you need to have those funds. You need to custody or control those funds. As a legal matter, the government couldn't prove that he transmitted funds just because everyone agrees that this tool is non-custodial, and the government didn't plead that the tool was anything other than non-custodial. So I think it was last October, Judge Fela ruled that the Bank Secrecy Act does not require custody or control. This was a very controversial ruling. I'm on the record as to saying I think that's totally wrong. But once that was decided as a matter of law, it was hard to expect a jury of Roman's peers who are not experts on cryptography or crypto or any of these sort of finer nuances of how the Bank Secrecy Act works to get this distinction. So I think the appeal that Storm is going to do now is probably going to be on Judge Fela's motion to dismiss decision more than it will be that on the jury's verdict, because I think at the end of the day, this really was more of a legal question, a factual question. I think with respect to this charge, it was probably pretty doomed by the time it went to trial in the first place.
Right. Alex, I know you kind of had the ear to the ground on this too. What are your observations and kind of concerns moving forward here?
Yeah, I think it is concerning. I totally agree with Zach's concern about the unhosted wallet or the non-custodial service or however you want to describe that Tornado Cash was, if you just sort of think about, the fact that the legal question, the fact questions were narrowed down so much to did criminals use it and did he know? That's why it's, I guess they're like, yeah, I mean, I guess he did know. There's evidence that he was aware. He surely couldn't have stopped it. So just like as a fundamental nature, and I appreciate Zach too clarifying the actual like meaning of that charge, because when you say like conspiracy to operate an unlicensed money transmission business, I think most of us think like that would be a business, right? Like that is like, and when you hear the word conspiracy, you think it means like, we're getting in together in a room together and we're hatching plans and we're planning and plotting. And the reality is like that just isn't what Tornado Cash was. Like that's not at all what it was. It just doesn't make any sense. So I hope that Roman has grounds to appeal. Every lawyer I've talked to, I know Zack is expecting appeals like that. Apparently there are a lot. I wasn't able to follow like the pretrial motions and stuff in this case, but it's a bad precedent for sure. It was a bad day for the internet and internet privacy, I would say, broadly speaking. And the other thing that really sticks out to me, and maybe this is a good segue into the FinCEN stuff, because FinCEN is an agency inside the Treasury Department that is tasked with overseeing and administering the federal registrations of money service businesses, right? And one thing that really sticks out to me about this, and not just the ruling, the case was started before the current administration was in office or the current DOJ was in power, and litigation and criminal and civil cases can go. It's weird. I mean, cases are complicated, right? So they can go different ways, sort of regardless of what policy ideas the people in power have. But Jay Clayton praised his team for stopping criminality. And if you read the presidential working group report, that came out, at this point a couple weeks ago, it's not particularly supportive of crypto's views on things like the Bank Secrecy Act. It's better, I think, than this DOJ SDNY trial team's view of this. But I think people don't necessarily realize that like Bitcoin and the crypto industry is getting all these wins on these things, but the financial surveillance apparatus that really escalated after 9/11 is quite intractable. And there are other it's not just crypto that cares about it, right? There's huge national security things, and rolling that back and sort of getting like you look at all the stuff that this administration has done that's positive for the crypto and Bitcoin industries, and then you look at this Roman Storm case, and it's kind of hard to square that circle. But the reality is like BSA, financial crime, illicit activity related stuff, AML, KYC, all of that stuff, they're not really rolling it back, not quite. So like that, people should remember that like, and by the way, most of that stuff is like pretty much the most important and existential policy issues. Which regulator regulates which type of token, it matters, but it's not like existential. And if software developers can be held liable for the use of their non-custodial tools, then we got huge problems across the whole stack here. So I think that's the thing that really stands out to me is the tension between the industry and FinCEN and Treasury and DOJ on this topic.
Yeah, I think that is a real tension. And I think some of this might be, it seems on the surface like there is sort of less money at stake on these questions of where exactly is the line of being a money transmitter versus not, whereas there's a lot of money immediately at stake about what's a security versus what's a commodity. But I think, Alex, you rightly point out, if you really interrogate the concept here, it's pretty obviously existential, right? So what was Storm convicted of? He entered into a conspiracy, right, which is an agreement between at least two people, and they took some step in furtherance of that conspiracy to operate a money transmission business that they knew would be used by criminals. So with most businesses, you're agreeing with at least one other person to do the business. So the conspiracy thing is pretty broad. The knowledge thing, also pretty broad, right? Makers of all sorts of tools know that criminals are going to use them. Apple knows that people are going to use MacBooks to commit crime. The companies that manufacture USB cables know that some people might use those to commit wire fraud. If you're part of a lumber company that chops down trees, maybe you think that some of that wood will go into paper that ends up in an envelope that one criminal will use to hand another criminal cash, right? So the knowledge part is really broad too. So then the question is, the only thing that's left is, what does it mean to transmit funds? And if it doesn't require that you custody or control funds in order to transmit them, besides the bastardization of the English language, if merely it takes, you need to create some tool that facilitates other people transmitting funds, then you do reach the lumber company, right? Certainly, you reach people who create non-custodial wallets, which is a software that helps you create private keys. You reach people who run nodes, right? If I use my Ledger wallet and I broadcast a transaction, I use Ledger Live software to send that transaction to the mempool. They are facilitating my movement of funds. Miners append transactions to the blockchain. Stakers, certainly any kind of DeFi protocol, layer twos, you name it. And so if Web3, if crypto, if Bitcoin is going to be worth anything at the end of the day, it's because it is this peer-to-peer trustless network. And if we're going to make it a crime to build any of the tools that allow people to use Bitcoin and crypto in that way, that's pretty short-sighted if we're going to mortgage that to have a safe harbor for ICOs.
And part of the argument that the DOJ made in this case regarding that FinCEN guidance was that the guidance didn't address the idea of control. But like that is fundamental to the concept of money transmission anyway. It's like, oh, it's almost a given, right? These laws and regulations were created so that when you go to a Western Union to send money to your grandma, the Western Union intermediary, which controls the funds between point A and point B, doesn't just abscond with the funds. That's why the rules are there, because they control, because money transmission involves control. And people have pushed. Remember, they had this insane argument about it that like even a frying pan that transmits heat would be considered like having control over the heat, and that
Yeah,
a
they were
USB
addressing
cable.
They were addressing the common sense argument that in order to transmit something, you need to have it. And they said a frying pan transmits heat and a USB cable transmits data, even though neither controls that thing.
Yeah. So it's been, luckily there is a statutory effort right here, the Blockchain Regulatory Certainty Act that Rep. Tom Emmer introduced in the House. That was included in the Clarity Act, which passed with a veto-proof majority, the Clarity Act. And it is in the Senate draft, the Senate banking draft of the Responsible Financial Innovation Act, which is their version. That does directly address this specific question, right, Zach?
Yeah, it both addresses this. And look, I don't want to let the government off too easy for claiming even that the guidance is unclear, right? Even if we're talking about privacy tools, there is a section of FinCEN's most recent guidance from 2019 about privacy tools. And they separate out privacy tools into two categories. They talk about anonymizing services providers and anonymizing software providers. And they say that if you're an anonymizing software provider, if you're providing software that allows people to spend money anonymously, you are not a money transmitter. If you're an anonymizing service provider, then you are a money transmitter. What's the difference? Twice in the sort of subsection about anonymizing service providers, they say that I'm reading a direct quote here, the added feature of concealing the source of a transaction does not change the person's status under the BSA. It has nothing to do with the privacy piece of it. The question is, are you accepting and then transmitting funds on behalf of the public? If so, you're a money transmitter. So this really is about control. It's not that there is explicitly, FinCEN says there's no special rule for privacy tools. So it seems pretty clear under the guidance that that's what this meant. And I think the President's Working Group memo, the 168-page crypto report that we talked about on the last episode, they talk about the Clarity Act and the BRCA codifying FinCEN's guidance. And so I think there is now pretty broad recognition that is in fact what that meant. We had discovery in the Samurai Wallet case where we knew that SDNY heard from FinCEN that that's what they meant. And in both the Samurai Wallet and the Tornado Cash cases, the government dropped the part of the money transmission conspiracy that directly alleged that the defendants needed a license under the Bank Secrecy Act. And so it is terribly unfair and precedentially dangerous that the Samurai Wallet guys pled guilty to money transmission, that Roman Storm was found guilty of money transmission, and the Clarity Act, or whatever the Senate version of that ends up being, is a full fix to this problem. It just says, listen, if there is any doubt under the statute, if you don't have unilateral, independent custody or control, you're not a money transmitter. In the vast majority of circumstances that we could see someone building a tool like that.
And you mentioned Samurai. This, what we've seen now, it makes sense if they thought the winds were blowing this direction, why they ended up doing a plea deal, right? I mean, this sort of proves their rationale. Is that true?
Yeah, the Samurai guys drew a really bad card in terms of the judge they ended up with. They had a very tough judge to begin with, Judge Berman, who was kind of on the older side and seemed to maybe not clearly grasp all of the technical parts of the case. And then he was swapped out for Judge Coate, who was sort of notorious in the Southern District of New York of being one of the most pro-prosecutor judges and someone who really throws the book at criminal defendants and gives really long, really harsh sentences, and who the first thing she did after inheriting this case was to basically summarily deny all of the motions from the defense, including the legal motion to dismiss, without hearing argument from the parties. And so they were looking at 20 years in prison if they were convicted of the money laundering charge. And so aside from any of the technical legal points, I think this was a very human decision of, Keone's 36, Bill's in his 60s. Neither of them felt like they could afford to risk 2 decades in prison.